Justice Minister Ronald Lamola says South Africa wants to stop the suffering of Palestinians. The country is asking the World Court to issue a provisional order to make Israel stop its bombardment of Gaza.
With the recent escalation of aggression of Israel in Gaza, South Africa has supported a UN resolution calling for an immediate ceasefire and the provision of humanitarian aid. Sadly, the world has not succeeded in stopping the genocide that is currently unfolding in Gaza. The international community has largely remained passive in response to these atrocities. Women and children in areas such as refugee camps, schools and hospitals have been targeted, leading to a humanitarian crisis. We saw unequivocally the UN Secretary General invoking a rarely used article of the United Nations Charter, Article 99. The Secretary General Antonio Guterres on the 6th of December 2023 called on the Security Council to press to avert a humanitarian catastrophe in Gaza and unite in a call for a full humanitarian ceasefire between Israel and Palestinian militants. This plea for Ubuntu, a plea for the humanity of the international community to prevail, was simply ignored. Israel's institutional impunity was reinforced. This court must stop Israel exceptionalism. In keeping with our obligations as a state party to the Genocide Convention, our government has approached the International Court of Justice to prevent the unfolding genocide in Gaza. We have also asked for provisional measures which include an immediate suspension of Israel military operation in and around Gaza.
The national chairperson of the South African Jewish Board of Deputies, Professor Milner, has criticised South Africa for taking Israel to the International Court of Justice over its war in Gaza. She says South Africa has chosen an anti-Semitic, ineffective route of a holocaust inversion.
The Genocide Convention was established in direct response to the industrial-scale wholesale murder of 6 million Jews. Similarly, the founding principles of the State of Israel were to be a refuge for Jews, so never again would we be subject to a holocaust. The attacks on Israel on the 7th of October were intended to be another holocaust. Make no mistake, Hamas admits it. This time, in the only place of refuge for Jews in the world. It was stopped by military means by Israel, long before it could achieve its genocidal aims, and a war of defense was started to fulfill the mandate of the State of Israel of never again. That this war, started by Hamas, who began it all, is now characterized by Hamas as a genocide, is Holocaust inversion, amongst the worst forms of anti-Semitism that exist, as it turns Jews' greatest grief and greatest fears against them. That the South African government has bought into this slur at the bidding of their friends Hamas is a disgrace. The tragic images unfolding in front of us of the devastation wrought by this war are horrific, and we mourn the deaths of every civilian on both sides. But the scurrilous charge playing on Jews' grief and fear is the least effective way to end this terrible war. It has been made clear time and time again that Hamas can end this war any time it chooses by releasing the hostages and stopping sending rockets into civilian areas in Israel. Surely these are not unreasonable demands, the release of hostages to allow babies, women, men and children to be returned to their homes. But Hamas chooses to prolong the suffering of Gazans and hold on to these hostages. It is unconscionable. It is further unconscionable that instead of using their friendship with Hamas to bring an immediate end to the rockets and to ensure that Hamas release the hostages, the South African government has chosen the anti-Semitic, ineffective route of Holocaust inversion.
Well, for a panel discussion, we're joined by attorney and legal analyst Thamsanqa Malusi, Wits international law expert, and Patrick Lukusa Kadima. and, of course, our SABC News reporter, Canny Maphanga. Before Canny wraps some of the key and crucial arguments from today, I just want to get a sense from the pair of you. By many accounts, if you look at all of the international reaction to this, the South African legal team put forward an admirable and a formidable argument, the collective of them. It was legally sound, it was detailed yet concise, and there were these 5 requirements that the ICJ requires in order to determine whether a threshold is reached or not. What did you make of how South Africa laid out that case? And maybe, Patrick, we kick off with you.
Okay, thank you, and good evening to your viewers. I think you have said it all. You know, it was a brilliant legal team, well composed. The arguments were flowing, you know, from one theme to another. And for me, particularly, you know, one thing that, you know, continued to excite me, if I may say, is how, you know, the evidence, you know, which is one of the most important things that the legal team brought, you know, forward, you know, statements from the United Nations agencies, what they have said about what's happening in Gaza and so on and so forth. It was just brilliant for me, given the short time, you know, that the statement was made when the presidency said they will be instituting these proceedings in different cities and so on and so forth. You have to give them their flowers, if I may put it.
Quick word from you, Thamsanqa?
Yeah, I think, Patrick has said it all. I think the one thing I'd probably add is, you know, the way the case was presented was so accessible to the common person as well, you know, which is not something that is easy to do with legal matters, because generally they are very complicated, and this was not, this matter also was just as complicated. But like, when I look at the reactions from the people on the social media, they mostly talk about how easy it was to understand and to follow, and I think that's credit has to be given to the legal team for making it as accessible as they did.
And I suppose, you know, just before we even continue, because I'd like to pick up on that point about the evidence, especially when you think about, you know, some of the videos from the officials in government trickling down to the soldiers and how, you know, South Africa intended to bolster its case there. But Canny, let's start with you, because you are also looking at the humanitarian aspect of this and how South Africa presented that case meticulously to document what is going on the ground. Give us a sense of some of the arguments there.
Well, indeed, this is a case of exceptional importance and underscores our shared humanity as South Africa. And you're seeing this country, undeniably, it's a proud moment to see South Africa take to the globe to seek justice for Palestinians in Gaza. And I think the most compelling submission was the first one we did see from Advocate Adila Hassim, who is a leading human rights and social justice advocate in South Africa, who detailed those 4 acts of genocide and spelt it out quite clearly from the start of the matter in the ICJ for us to clearly understand what it is that we're dealing with here in Gaza and the severity of what we're facing. So the first genocide act that Hassim highlighted is the displacement of Palestinians in Gaza. Let's take a listen to what she provided to the ICJ there.
Israel has deliberately imposed conditions on Gaza that cannot sustain life and are calculated to bring about its physical destruction. Israel achieves this in at least 4 ways. First, by displacement. Israel has forced the displacement of about 85% of Palestinians in Gaza. There is nowhere safe for them to flee to. Those who cannot leave or refuse to be displaced have either been killed or at extreme risk of being killed in their homes. Many Palestinians have been displaced multiple times as families are forced to move repeatedly in search of safety.
In the second act of genocide, she further highlighted Israel's refusal to allow sufficient aid.
Israel's campaign has pushed Gazans to the brink of famine. An unprecedented 93% of the population in Gaza is facing crisis levels of hunger. Of all the people in the world currently suffering catastrophic hunger, more than 80% are in Gaza. The situation is such that the experts are now predicting that more Palestinians in Gaza may die from starvation and disease than airstrikes. And yet Israel continues to impede the effective delivery of humanitarian assistance to Palestinians, not only refusing to allow sufficient aid in, but removing the ability to distribute it through constant bombardment and obstruction.
And the third act, then, of course, she highlights the denial of adequate shelter, clothes, or sanitation.
Israel has deliberately inflicted conditions in which Palestinians in Gaza are denied adequate shelter, clothes, or sanitation. For weeks, there have been acute shortages of clothes, bedding, blankets, and critical non-food items. Clean water is all but gone, leaving far below the amount required to safely drink, clean, and cook. Accordingly, the WHO has stated that Gaza is experiencing soaring rates of infectious disease outbreaks. Cases of diarrhea in children under 5 years of age have increased 2,000% since hostilities began.
Then, of course, sticking to the theme of the destruction of core institutions in Gaza, she then speaks on the military assault on Gaza's healthcare system, which renders life unsustainable.
Even by 7 December, the UN Special Rapporteur on the right to health noted that the healthcare of infrastructure in the Gaza Strip has been completely obliterated. Those wounded by Israel in Gaza are being deprived of life-saving medical care. Gaza's healthcare system, already crippled by years of blockade and prior attacks by Israel, is unable to cope with the sheer scale of the injuries.
So those 4 acts of genocide wraps up one of the submissions into South Africa's claim regarding the response to the October 7 attacks and the historical treatment of Palestinians in Gaza.
And thank you very much, Canny, for wrapping it up for us. And if we can, Patrick, get into the part about the evidence, particularly on genocidal intent, because a number of people have been saying it's difficult to prove, and we're going to get to that in just a moment. But how far do you think the case to prove that went, especially when you look at the aspect where a video was played of, the Israeli Prime Minister, some of the officials, and then juxtaposing that with what was happening on the ground with the soldiers who themselves had, quite a lot to say about what was happening and unfolding before their eyes. Do you think South Africa managed to put forward a strong argument to highlight intent there?
Yeah, I think, first of all, international law is very complex. It's not as easy as we see it on the face. There's a lot of, politics that goes behind it. It's not devoid from politics. But the legal team put a very strong case, I would say, basing it on the convention, the Genocide Convention. We have seen also the legal team, going to give precedence of what the International Court of Justice has said in previous cases. And the doctrine of precedence is an important one in international law. We have the Gambia versus Myanmar case that the International Court of Justice had intervened and had given provisional measures in that case. Now, we see the evidence that has been given, and out of respect, we saw the legal team saying they would not be showing certain graphic images and videos out of respect and solidarity of the Palestinian people, which should be also commended. But it is there. It is there. You can't deny. You can't, from the papers, the 84 pages that was instituted by the legal team, you will see, even if you want to deny those images, the statements from those United Nations agencies, those chief economists at the United Nations is very clear. WHO is there. I remember reading something from WHO when they went to Gaza and they were told to use certain routes and so on and so forth. And when they arrived there, they said this is horrific. The United Nations Secretary General himself, after the United Nations Security Council told him that, okay, look, we have passed this resolution, go on. He writes and he tells you, look, you are telling me to do this, but I need guarantee on the safety of my workers. I need guarantee on this. It's still difficult to carry out this job. So the legal team put in so much work, put in fact. The International Court of Justice itself has said that genocide also falls under customary international law, which means that the court has previously stated that when in its judgments, things like genocide should be prohibited, that also it goes to an extent of extraterritorial, meaning that countries that have the power, to tell another state, to stop what they are doing, should intervene.
I want to home in on that point in a little more detail. And Thamsanqa, let's do that with you. And Lukusa focused on the genocidal intent, and he made this really compelling connection between the words and actions of the Israeli executive, including the Prime Minister Benjamin Netanyahu, the political leaders, the commanders, declaring in explicit terms what he said was genocidal intent. What happened then, by the way that he laid out his argument, was that the soldiers then enacted that intent on the ground, that it has been nurtured at the highest levels of state and wasn't just something that happened on the fringes. How important was it to show that connection between statements made right at the very beginning, during, and even now, and the action of troops on the ground?
Yeah, I mean, that was really important. The starting point is that in order to prove a crime of genocide in terms of the Genocide Convention, you have to show that genocidal acts were committed with the intention to destroy a protected group. So that's why intention was very important there, and that's why Advocate Lukusa dedicated his presentation at the ICJ to intention. And intention does not actually have to be actual in the sense that it is declared that I'm intentionally going to destroy this group. It can be inferred. In most cases, in fact, it is inferred from the conduct of the relevant authorities. In this case, Advocate Lukusa took statements made by the Prime Minister Benjamin Netanyahu and other senior government officials to the effect that showing that the statements that they were making was a declaration of intent to destroy the Palestinian people as a protected group, and that filtered all the way down into the soldiers that are actually on the ground. He made the point that Benjamin Netanyahu is the commander-in-chief of the army in Israel. And if he says a statement, he makes a statement, that is declaring war against Hamas, against the people of Palestine, and that actually gets affected by the soldiers on the ground, there's not a better connection of intent than that one. So I think, in my opinion, he made a really compelling case of intent.
Kenny, we're going to come back to you just now, but I'd like to stay with you on that point, because there's a question that then arises, especially at the back of, genocidal intent. Would you say then accusing Israel of acts of genocide is inadvertently accusing the US of the same, because they're aiding and they are the ones that are also bolstering what we are seeing coming from the Israeli side?
Yeah, I mean, you may well make that case, but I don't think that's the case that South Africa is making. South Africa's case is against Israel. I mean, it's against the government of Israel, that they've committed acts of genocide against the people of Palestine in the Gaza Strip. So that's a pleaded case. That being said, complicity to genocide is a crime under the Genocide Convention, and so South Africa did not make that case. It may well make it in the future. For example, if an order is given by the ICJ that Israel has committed acts of genocide, and then they should stop committing acts of genocide. If the US continues to provide arms to Israel, or continues to provide the support that it's been giving to Israel so far, that may well amount to complicity to genocide, which may be punishable under the Genocide Convention.
For those of you who weren't able to follow these proceedings today, just a look at our legal team as we work through some of the high-level submissions that they made at the International Court of Justice in the Peace Palace today. You see the faces, we've already mentioned some of them: Dr. Adila Hassim, Advocate Thembeka Ngukai-Toby, Professor John Dugard, Blin Gralich, Professor Max du Plessis, and Vaughan Lowe. We're going to be talking a lot more about them.
We are unpacking the developments in the International Court of Justice, as we saw earlier on. South Africa presenting its application. We are joined in studio by Thamsanqa Malusi, attorney and legal analyst, Patrick Lukusa, Wits international law expert, Canny Maphanga, SABC News reporter, and looking at some of the arguments. Canny, let's start with, just as you wrapped the day for us, but let's talk to the viewers about what this process means. Is it a permanent order? Is it a provisional order? What exactly is South Africa looking to get from the International Court of Justice?
Well, thank you, Bongiwe. Well, the court is not dealing with a final determination regarding the issue of genocide. If I could compare it in a South African context, it would be the equivalent of a party heading to the civil court in an urgent matter to seek urgent relief, and if they're not able to get that interim relief, then they'll suffer irreparable harm. So what the South African government is doing is that they're saying that in these 13 weeks we've been able to show you that this is the kind of harm that has been suffered, and without these provisional measures, if you do not provide us or indicate these provisional measures, then you can deal with even more risk of a genocide in Gaza. So this is just an interim measure. Then, of course, if you expect for those that matter to be discussed further, it could take much longer for the merits to be discussed, as a finding such as genocide is quite a complex matter to deal with and can take some time to reach a final determination. So the only question the court has to deal with now is whether South Africa's complaint before the ICJ is actually plausible. And without those measures that they are seeking in that court, would Palestinians in Gaza suffer irreparable harm?
And it seems by all accounts that this could actually be a decision that's made, within a matter of probably even less than 2 weeks. So on that urgent basis, as you say, there could be something forthcoming. Before we move on to jurisdiction and some of the other elements that the legal team raised, just on the merits aspect, what actually happens? So Advocate Lowe was, very clear about or King's Counsel Lowe was very clear on what was being asked from the court, as Canny has just explained, saying that, the bigger case can only be made at the merit stage. Talk to us about what this merit stage actually encompasses, Patrick. You've probably seen it before in other similar cases brought before the ICJ.
So essentially, the merit stage will involve a more compelling argument that both countries will put forward in front of the judges. It will be dealing with more in-depth matters, such as whether a genocide, was really taking place, and so on and so forth. So as we have stated earlier on, for now it's just the provisional measures, but when it gets to the merit stage, it's about the arguments and the in-depth effects that will be presented by both legal teams at a later stage.
And Thamsanqa, when you watch the case and you watch, the different, advocates speaking about, the atrocities that are happening there, one gets a sense that there was a thread to try and create a pattern of history in order to say it didn't just start on October 7th. There's a lot of history that dates back to the 1940s. How critical is that, particularly in a case like this one, to create a pattern for the court to be able to see that this is not just a once-off strike? Yeah,
with this case specifically, South Africa pegs its starting date on October the 7th, 2023, when Hamas obviously invaded Israel, and then Israel retaliated. So that's the starting date of the genocide, because you want to be able to create a time frame where you can say with some degree of certainty that genocide was happening within this time frame, which is why they've pegged it on this date. That being said, you cannot ignore the fact that this conflict is operating within a political context in Israel-Palestine that has existed since the 1940s, right? Many human rights organizations, including International Human Rights Watch, have dubbed Israel as an apartheid state. And that is the basis, one may argue, why Hamas retaliated, did what it did on October 2023. So, as much as the actual case of genocide is pegged on October, it is happening within a context of a war between Palestine and Israel, which gave impetus to the events of October 7th.
And to pick up on that, there was also a history painted of South Africa's trying to resolve this independently, one-on-one, reaching out to Israel, not only with the démarche and most recently the note verbal, but also at the UN Security Council, at the UN General Assembly. Why was it important, Thamsanqa, to make that connection as well?
South Africa had to do that because in order for South Africa to bring a case on a genocide convention, they needed to show that there was a dispute, that there's a dispute that exists between Israel and South Africa as members of the genocide convention. The reason why they did that was to show that they said a genocide is being committed. We're telling you that the genocide is being committed by yourselves in Israel, and Israel did not disagreed and often ignored, the note verbal and all the other measures that South Africa took. And so just because then South Africa made all these efforts to resolve the issue outside of the court, Israel did not, take heed of what South Africa was saying. That means that there's a dispute, and that means then it has to be adjudicated by the ICJ in terms of the convention. So that was the legal reason beyond, I'm pretty sure there were genuine reasons why South Africa made those efforts to try to resolve the issue before the ICJ. But on a legal front, it gives them a reason now to say there is a dispute because we don't agree that you don't think there's a genocide, we think there's a genocide. That constitutes a dispute that needs to be adjudicated by the ICJ.
And interestingly, Canny, some of the viewers were asking the question just as the proceedings were going on to say, why is Hamas not involved?
Well, I think that was clearly explained during proceedings that they are not a member state. They are merely just an organization that carried out this attack. So in order to actually bring this application under the convention, you actually have to be party member states in order for them to adjudicate on this dispute, as Thamsanqa has eloquently explained. Now, because Hamas is just an organization that carried out attacks and invaded Israel, it's impossible to bring that organization to the ICJ. There may be other avenues to pursue that, but not in this court.
So again, it was just covering so many, as we said in the beginning, it was such a pinpointed, it had to have the detail to meet the requisite legal threshold, but at the same time it was so concise and well constructed and put together. I'd like your observations on some important utterances and arguments that were made at the court today. Patrick?
So for me, what stood out was the humanitarian access. The situation there. I think that's the most important that has been in the headlines everywhere, at the UN and so on and so forth. The United Nations Security Council had failed to resolve it numerous times, because certain members were vetoing these resolutions. So the humanitarian access, the issue of the military and how they conducted themselves, their modus operandi, was also something that stood out for me. What stood out for me again was how Advocate Ngokaitobi eloquently, which I think was one of the most difficult tasks the legal team had, that he took out very brilliantly, as well as Prof. John Dugard, on the issue of jurisdiction, which is very important, because if the court does not have jurisdiction, then it's going to throw it out. So he did it very well, I think, Prof. John Dugard, very short and straight to the point. It just shows the experience that he has had, over the years, sitting as an ad hoc judge in the court and his role in other international organizations. So those are some of the things that stood out for me, and yeah.
For me, I would say, as much as this was the interim measure, and as Canny was saying, you don't have to actually prove full-on genocide. When I looked at the case, South Africa was actually making a case for genocide in the fullest extent. I don't think that the case on the merits will be too dissimilar to this interim provisions measure case. They might provide a little bit more evidence, but I think the structure of how they're going to present the case will be precisely the same, because they have gone far enough, in my opinion, to not just prove that there is a probable case of genocide, but that in fact there is genocide that is being committed in the Gaza Strip. So that's what stood out for me. I don't know if there's going to be any more that they would have to do come the merit stage of the case to show that there's actually genocide that is being committed.
And when you go through that 84-page application, you can see that South Africa meticulously thought through its case and really putting its best foot forward there. But let's thank you for your time.